Welcome back to the James for Justice podcast, where we talk about all things related to the criminal justice system, like criminal justice reform, criminal defense work, police officers, law enforcement, judges, probation officers, prosecutors, everyone and everything related to the criminal justice system we will discuss in order to make the criminal justice system more humane and just. Today, I want to talk about arraignments, and I want to keep this podcast short. I want this to be something that can be helpful for newer defense attorneys, as well as something that can remind or encourage other more seasoned defense attorneys to really take advantage of the opportunity at the arraignment. Because as we all know, the arraignment is the first hearing of the legal process for someone accused of a crime. And it's really the first opportunity for us as defense attorneys and for our clients to make a positive impression on the judge handling the case, and also to make a positive impression on the prosecuting attorney or DA or the U.S. attorney who is handling the file, who brought the charge or charges. We cannot underestimate the power of our influence as defense attorneys. Even at the arraignment, when it seems like the deck is stacked against our clients and against us, the truth is that it's not, because our clients actually have a lot of power and leverage even at that first hearing because of the presumption of innocence. As a defense attorney, it is our job, first of all, to focus in on what our clients' needs are as we begin the process of handling their criminal case. What are their needs? In other words, do they have a job they need to get to? Do they have a home they need to pay a mortgage on? Do they have rent to pay? Do they have bills to take care of? Do they have a spouse or children to take care of while they're going through the legal process? When we can evaluate all of the things that our clients really need to do, just as normal human beings in society, while their case is pending, we can take stock of that information, put together a compelling argument for the judge to consider a low or reasonably low bond or a personal recognizance bond. So the first thing we really need to do is focus in on our clients' needs. What are their needs for the next 6 months, year and a half, 2 years, however long it might take to handle this case? And then secondly, take time to prepare for the arraignment. I see way too many attorneys who just walk into the arraignment without any preparation, as though they're going to get some positive outcome for their client. But if they had taken 10, 15, 20 minutes to take stock of all the positive information, background information, positive history that the client brings to the table and to their case, put that together in a compelling argument, things could be much different for most defendants and defense attorneys at arraignment. An ounce of preparation is worth a pound of cure. There's a little work up front can save you major headaches across the lifespan of your case. If you keep your client out of jail or get your client out of jail at the arraignment, there's going to be a lot less fighting down the road about how to get your client out of jail or how to lower bond, how to spend more time with your client preparing for his or her case when they're in jail versus being out of custody because you won at the arraignment and you got a low bond secured. So those are two critical pieces. The third real principle I think many of us forget, or many of us, again, give too little weight to, and that is that the judge is a human being like the rest of us, might be a magistrate at the arraignment, and that person has to make a decision whether to trust our client on a bond out in society while their case is pending or not. And that trust factor is going to be critical, because if we can build trust as defense attorneys who know, oftentimes we know the magistrate or the judge who's handling the arraignment, we can be the trust building person in that situation. Because the arraignment really, in my experience, is all about building trust with the judge or magistrate in order to get a low bond secured. To help the judge or magistrate understand our client is trustworthy. That's where preparing and highlighting the positive highlights about our client or a client's history or a client's life story or the people that know our client, the people that support our client. Taking time to prepare all of those factors and elements into a compelling, persuasive argument at the arraignment can be key to securing a low bond or a personal recognizance bond or unsecured bond. Different jurisdictions call it different things. The point is, we want our client out of jail while their case is pending so that if it takes a long time, because we want to put together an impactful defense strategy, our client is not in jail languishing while this case remains pending. And that gives us as attorneys a lot more liberty to take the time we need to build the right defense strategy and allows our clients the opportunity to live something of a normal life like they had before they got arrested or charged with serious crimes. When you encounter a prosecutor or a DA or U.S. attorney at arraignment who suddenly throws you off your game, and this is the last key point I want to make. Okay, be prepared for that. First of all, know that the prosecutor or U.S. attorney is going to throw all sorts of negative garbage out there to convince the magistrate or judge that your client is not worth trusting, not worth allowing a low or personal recognizance bond for. But you will be prepared if you take time to prepare for the arraignment to counteract the prosecutor's points. The prosecutor mainly will be looking at whatever past criminal history your client already has that's on public record and what the allegations of the charge or charges are. Focusing on those things in order to try to highlight all the negative things about your client to keep him or her in jail or to have him or her locked up. Prepare yourself to counteract that. When you do, then you will again continue to build the trust with the magistrate or judge. Continue to build a trust bond so that when you are expressing to the judge or magistrate all of these positive things about your client who's next to you, and you can show some sense of connection with your client. I'll put my hand on my client's shoulder. I'll look to my client and have him or her basically affirm some of the things I'm saying with a head nod. I want to look at my client. I want to look at the judge or magistrate in order to kind of build this triangle of trust. And when you do that, when you as an attorney who presumably doesn't have any criminal record comes into the court with someone who even has a criminal history of some sort, could be even a bad criminal history, when you can build that triangle of trust between the judge and magistrate, your client and you, then you're going to send signals, positive signals, to that judge or magistrate that's going to build trust and confidence in giving you what you're asking for because you trust your client, and therefore the judge or magistrate can trust you in order to trust your client. I see way too many attorneys who just walk up to the podium and kind of throw out a few positive factors about their client. Or worse, don't really know any background history about their client. Don't have anything positive to say to the judge at arraignment. And what happens? They get locked up on a $100,000 bond. They get locked up on a bond that they can never post. So the key at arraignment, if you want to essentially win or have an impactful arraignment, is to build the bond of trust between the judge, you, and your client with a compelling, persuasive argument as to bond, as to why the judge or magistrate can trust your client to be out on a low bond or even a personal recognizance bond. And that, my friends, has been a strategy I learned from more seasoned attorneys. And then when I implemented it in my own practice and began to polish it and make it better with time, it works almost without fail. Of course, there's going to be cases where if it's a homicide charge, there's going to be a high bond. But in most cases, I've been successful in getting clients out of jail or keep them out of jail while their case is pending by using these simple strategies to build trust with the judge or magistrate. I hope that helps. If you like this podcast, if you think it's helpful, please hit the thumbs up button, like it, subscribe, share it with your friends and colleagues. Help spread the word that we together can make the criminal justice system a better, more humane, and just legal system.